My brother called me at 6:47 inches the morning. Not a normal hour for him. He'd never been an early riser. Not once in the 51 years I'd known him. I remember sitting up in bed, heart already wrong before I even pressed the phone to my ear. His voice came through jagged and wet, the way voices sound when a person has been crying for a while and run out of the soft part of crying. "You've taken everything from me," he said. "Everything. How could you do this? To your own brother." I didn't answer right away. I sat in the gray January light coming through the bedroom window, and I listened to him fall apart on the other end of the line, and I thought about the afternoon 3 months earlier when I'd come home from the hospital and found out what he'd done. I thought about my wife, Patricia, who'd passed 4 years before and who had always said my brother had soft hands and a restless eye. I thought about the 37 years I'd spent working for the Canada Revenue Agency and everything I'd learned about what happens when people believe they've found a way to take what doesn't belong to them. "I'm not the one who took anything," I said, and I hung up. Let me go back to the beginning. My name is Robert Gauthier. I'm 64 years old. I spent my career in tax compliance at the CRA, Ottawa District, starting as a junior auditor in 1987 and retiring as a senior compliance officer in the spring of 2024. 37 years of looking at other people's numbers and finding the places where the story didn't hold together. Patricia used to say I had a gift for it, for sensing when something was being hidden. She said it came from growing up in a house where things were never said plainly. She wasn't wrong. Patricia passed in the fall of 2020. Pancreatic cancer. 6 weeks from diagnosis to the end, which the doctors told us was mercifully fast, and which I've spent 4 years learning how to accept. We'd been together since university. We met at Carleton in 1981, at a Friday night social in the residence commons that neither of us had particularly wanted to attend. She was studying social work. I was studying accounting. She used to joke that between the two of us, we covered the full range of human misery. After she passed, I moved through the grief the way I moved through most things. Methodically, one day at a time, one task at a time. I kept the house on Glebe Avenue, in the south end of Ottawa. I kept Patricia's garden. Badly at first, and then better. I managed the 2 things she and I had built together over the decades: our joint investment account at TD Waterhouse and the rental property on Baseline Road, a modest 3-unit building we'd purchased in 2003 and paid off by 2018. The rental income covered my property taxes and gave me a steady $1,200 a month on top of my pension. It wasn't wealth. It was security. It was Patricia and I working for 30 years to make sure our final years would be stable. My brother Daniel is 13 years younger than me. 51 now. He'd had a scattered kind of life. 3 years of college, dropped out. A string of sales jobs, some of them decent for a while. 2 marriages. The first ended badly when his wife found out he'd borrowed heavily against their joint line of credit without telling her. The second ended more quietly, the way things do when the fire has just gone out. He had a daughter from the second marriage, my niece Isabel, who I adore and who has her mother's good sense. Daniel moved back to Ottawa from Calgary in 2022, after the second divorce. He'd been staying in a sublet in Vanier, the East End, and taking contract work in sales and installation for a solar panel company. Not struggling exactly, but not settled either. I'd helped him here and there, a few $100s when he'd asked. A meal on Sunday evenings. Patricia had always said Daniel needed steadiness around him, that he did better when someone was watching out for him. She'd said it with warmth, the way she said most things. I'd tried to honor that after she was gone. In March of last year, I had a stroke. A moderate ischemic event, my neurologist called it, affecting the left hemisphere. I was at home when it happened, in the kitchen, reaching for my morning coffee, and then I was on the floor, and the coffee was on the ceiling, and I couldn't remember the word for the thing I'd been reaching for. The ambulance came. I spent 8 days at the Ottawa Hospital on Smith Road, and then 3 weeks in rehabilitation at a facility in Nepean. Before the stroke, I'd been in the process of updating my legal documents. Patricia's death had made that clear. My daughter Claire, who lives in Halifax with her husband and 2 children, was listed as my power of attorney for personal care, and I had intended to name her for property as well. But the stroke came before the paperwork was finalized. And in the hospital, confused and frightened and trusting in the way illness makes you trust, I signed a temporary POA for property in my brother's name. Just until I was recovered. Just so someone could manage the accounts, pay the utilities, make sure nothing fell through during the weeks I was unable to manage it myself. Daniel had come to Ottawa when he heard about the stroke. He'd been attentive and calm in the hospital. He'd driven me to my rehab appointments. He'd watered Patricia's garden without being asked. I remember being moved by that. I remember thinking Patricia had been right about him needing steadiness, and that perhaps being needed brought something out in him. I was back in my own home by the end of April. The aphasia had mostly cleared. I was slower, more deliberate, but functional. My cardiologist was pleased with my recovery. The POA I'd signed for Daniel was no longer necessary, and I'd intended to have it revoked. I'd called my lawyer, Frances Pham, at her firm on Bank Street, and left a message about scheduling an appointment. Before that appointment happened, I got the call from my tenant. His name is Marcus Osei. He's lived in the upper unit on Baseline Road for 6 years, and he is one of the most dependable people I've ever known. He called me on a Tuesday afternoon in June to say that a man had come by the building with a real estate agent and walked through all 3 units. He said the man had introduced himself as the property owner. He said the man looked like the photos of my brother that he'd seen on my refrigerator when he'd helped me carry groceries inside the previous winter. I sat very still on the couch and asked Marcus to repeat what he had said. I called TD Bank the following morning. My property account and the investment account Patricia and I had built together were both still intact. But when I called Scotiabank, where I'd held a secondary account I used specifically for rental income management, the one Daniel would have had access to under the POA, the customer service representative told me there had been a change of address notification filed on the account 3 months earlier. The mailing address had been updated to an address in Collingwood, Ontario. I had no property in Collingwood. I had never lived in Collingwood. I didn't know anyone in Collingwood. I called Frances that afternoon and told her everything. She was quiet for a moment and then she said, "Robert, I need you to contact a real estate lawyer and have a title search run on your Baseline Road property immediately. And I need you to prepare yourself for what that search might show." The title search came back the next day. The property on Baseline Road had been transferred in May, 6 weeks earlier, while I was still finishing my rehabilitation. Still slower than usual, still trusting my brother to manage the things I couldn't manage yet. The transfer had been executed under the power of attorney I'd signed in the hospital. The property had been sold for $412,000 to a numbered company. The proceeds had flowed through the Scotiabank account and then out. $412,000. Patricia's and my 37 years of payments, of repairs, of management, of patience, gone. I didn't call Daniel. Not yet. Frances referred me to a litigation lawyer named Andrew Vaux, whose office was on Elgin Street. 3rd floor, a quiet space with diplomas on the wall, and the kind of stillness that expensive lawyers cultivate because clients need it. He was in his early 40s, precise in his speech, the kind of person who took notes by hand in a leather-bound book and never seemed to hurry. He reviewed the documents I'd brought and said, "The good news is that this is not legally ambiguous. A power of attorney for property does not grant the right to transfer property for personal gain. That's codified in the Substitute Decisions Act. What your brother did is a breach of fiduciary duty, and it meets the threshold for criminal fraud under the Criminal Code. The question is, how we proceed. What are my options? We file a civil claim for conversion and breach of fiduciary duty. We report to the OPP's Financial Crimes Unit. We also, given your background, may want to consider what CRA would make of an individual who received $400,000 in property proceeds and may not have reported it." I understood what he was suggesting. "I want to know what he did with the money first," I said. Andrew hired an investigator, a retired OPP detective named Shirley Nakamura, who worked out of a small office in Canada and charged for her time in a way that made her worth every dollar. She took 3 weeks and came back with photographs and documents laid out in a manila folder that she set on Andrew's desk without ceremony. Your brother, she said, has been busy. He had bought a new truck first. A fully loaded Ford F-150 Lariat, dark navy, $31,000 down at a dealership in Barrie, financing the rest through a Scotiabank auto loan. She had photos from the dealership's security camera showing Daniel grinning at the sales manager, the kind of grin that only comes when someone has money they didn't work for. He'd bought it 2 weeks after the property transferred. Then the Chalet, a ski property near Collingwood, at the edge of the Blue Mountains. Purchase price $420,000. Down payment of $110,000. Mortgage for the rest through a local credit union. Purchased under his own name in June. 3 bedrooms, vaulted ceilings, a wood stove, and a view of the escarpment. The kind of place Patricia and I had looked at once, on a weekend trip to Collingwood years before, when the children were young, and decided we couldn't afford. He'd spent roughly $141,000 in cash in under 8 weeks. Where's the remaining $271,000? I asked. Shirley spread her hands. Likely distributed across accounts we don't have access to yet. Some, possibly moved to cash. He may have been cautious enough to slow walk it. A number settling in my chest. Not anger, not grief. Something more like the feeling I'd had thousands of times over 37 years at the CRA, the recognition of a discrepancy that needed to be corrected. How much did he report as income last year? I asked. Shirley looked at me for a moment. 43,000, T4 from the solar company, first half of the year, and then contract income. No capital gains. No large gifts reported. I nodded slowly. He hasn't filed a property income disclosure either, I said. A $400,000 property disposition. No principal residence exemption available, because it wasn't his principal residence. He owes capital gains on the full amount, calculated at Patricia's, and my adjusted cost base from 2003. Andrew looked at me. You're going to report him. I spent 37 years reporting people who took what wasn't theirs, I said. This is no different. That evening I filed a tip with the CRA's Leads program. I knew the form well. I'd seen hundreds filed over my career, and I'd investigated dozens. Suspected unreported income. Individual received proceeds of approximately $412,000 from the sale of a property held under a power of attorney. Property was not owned by the individual. Proceeds do not appear to have been reported. Individual purchased a recreational property and a motor vehicle in the weeks following receipt of funds. Details attached. I included Shirley's photographs. I included the title transfer documents. I included Daniel's last 2 years of publicly accessible corporate filings and what we'd found of his bank records through the civil discovery process that Andrew had already begun. Then I submitted it and sat back in my chair in the house on Glebe Avenue and listened to the May rain come down outside. I hadn't spoken to Daniel since before Shirley's report. He'd called twice while I was in the investigator phase and sent a text that said, "Robert, I think there's been a misunderstanding about the Bassline property. I want to explain." I didn't respond. Claire had called from Halifax, upset and worried, and I'd told her calmly what had happened. There was a silence on the line that lasted a long time. "Dad," she said finally. "I'm so sorry. I should have been there." "You're there now," I said. She offered to fly to Ottawa. I told her to wait until there was something to come for. Daniel hired a lawyer. His name was Craig Hollis, a solo practitioner out of a shared office space on Rideau Street, who seemed, based on our lawyer's correspondence, to specialize in telling clients what they wanted to hear. His initial position was that the property sale had been a necessary and authorized action under the power of attorney, taken to consolidate assets during my period of incapacity, that the money had been held in trust for my benefit and would be returned at the appropriate time. Andrew forwarded me their letter with a single, handwritten note at the bottom. They know they have nothing. We were in the discovery phase of the civil proceedings when Daniel appeared at my front door in September. I was in the garden, cutting back the hydrangeas before the frost, and I heard the gate open and looked up, and there he was. He'd lost weight. The easy confidence I associated with him, The thing that had always either charmed or unnerved people depending on the day was gone. He looked like a man who had been indoors for a long time, not sleeping well. Robert. He stopped at the edge of the garden path, hands in his jacket pockets. He was wearing a jacket I didn't recognize. Good quality. Something he'd bought with my money. I kept cutting. I'm not going to talk to you outside of a legal proceeding. I just want to explain. Your lawyer can explain to my lawyer. That's how this works now. He stood there for another moment. I could see him assembling something, some version of the speech he'd prepared. I didn't look up again. Eventually, I heard his footsteps retreat and the gate click shut. I went inside and called Andrew to document the visit. The CRA letter arrived at Daniel's address in October. Shirley had a contact who could confirm receipt without disclosing investigation details. The letter requested documentation of all income sources for the previous tax year, explanation of the property disposition in May, and clarification of the surrogate funds for the vehicle purchase and the Collingwood property down payment. Response required within 30 days. Andrew filed the civil claim formally in October. Statement of claim. Ontario Superior Court. Robert Jean-Paul Gauthier, plaintiff. Daniel Marcel Gauthier, defendant. Relief sought, $412,000, plus interest, plus costs. Causes of action. Breach of fiduciary duty under the Substitute Decisions Act. Conversion, unjust enrichment, fraud. The process server found Daniel at the Collingwood property on a Thursday morning, according to Shirley's photos. He was in the driveway loading ski equipment into the back of the F-150 when the server walked up the front path. In the photo, his expression is the kind that doesn't change, a face that has absorbed the thing it was trying to outrun and has nowhere left to go. He called me that evening from a number I didn't recognize. I answered because I'd been expecting it. You sued me, he said. His voice was low and strange. Your own brother. You sold my property, I said. You took $412,000 that Patricia and I built over 37 years. You used it to buy yourself a truck and a ski chalet. And now you're surprised there are consequences. I was managing your affairs. That's what the POA authorized me to do. You weren't capable. I'm capable now. You'll lose, he said. I have documentation that shows your state of mind during recovery. I have medical records. My lawyer says we can argue capacity issues with the original property, that you'd always intended to consolidate. Your lawyer, I said, is telling you what you want to hear. See you in court. I blocked his number. The winter moved slowly. Toronto had an early snowfall in November that swept up to Ottawa and shut the city down for a day. I shoveled my walk, and the walk of my elderly neighbor Mrs. Kowalczyk on one side, the way Patricia and I had always done, and I made coffee and sat by the window and worked through the documents Andrew had sent for the upcoming trial. There was something clarifying about the process. 37 years of compliance work had given me a tolerance for detail that I'd always considered simply professional. Now it felt like a tool. Claire flew in for a week in December with my grandchildren, 8-year-old Liam and 6-year-old Sophie. They knew something adult and serious was happening, but not the details. Liam asked once where Uncle Daniel was. I told him Uncle Daniel was dealing with some problems he'd made for himself. Liam considered this with the gravity of an 8-year-old who suspects he's receiving a lesson. The civil trial began in the last week of January, Ontario Superior Court in Ottawa. Justice Bernard Okafor presiding. A quiet courtroom, the kind that seems smaller than you expect until the proceedings start, and then becomes exactly the right size. Craig Hollis built his case on 3 pillars. First, that the POA had authorized Daniel to act in my best interests, and that the property sale had been a judgment call made while I was incapacitated. Second, that the money had been held in trust, and that any perceived misappropriation was a misunderstanding about timing and accounting. Third, that my subsequent actions, the CRA complaint, the civil lawsuit, the investigator, constituted harassment of a family member who had acted in good faith. Andrew took each of these pillars apart methodically, the way you would deconstruct a failed load-bearing wall. On the first point, the Substitute Decisions Act is explicit. An attorney under a POA for property may not benefit personally from property transactions. Selling my building and directing the proceeds to his own accounts was not a judgment call. It was textbook conversion. On the second, Daniel could not produce a single document showing the funds had been held in trust. No trust account, no written record, no communication to me indicating the funds existed or were being managed on my behalf. The money had flowed directly into his personal accounts and out into his personal purchases. On the third, Andrew produced a single exhibit, the Ontario Freedom of Information records, showing that I had requested the revocation of the POA in mid-April before the property was sold in May. I had left a voicemail for my lawyer, Francis Pham. I had sent an email to my bank. Daniel had been aware from our conversations that the arrangement was temporary. He had sold the property after I had already expressed intent to revoke in the narrow window before the legal paperwork could be completed. He knew, Andrew said. He acted before the window closed. Daniel took the stand on the second day. He was coached well enough to be controlled in direct examination. When Andrew cross-examined him, the control began to slip. Mr. Gauthier, when your brother left the hospital and entered rehabilitation, did he communicate with you about the property on Baseline Road? We discussed it. Yes. Did he instruct you to sell it? He implied that he wanted his affairs simplified. Did he say the words, "Please sell my property"? He indicated. Yes or no, Mr. Gauthier? Did your brother instruct you in writing or verbally to sell the property on Baseline Road? Not in those specific words. At any point between March and May, did you send your brother a written communication advising him that you were considering selling the property? I didn't want to burden him while he was recovering. Did you inform him of the sale after it was completed? I planned to, once he was stronger. When exactly did you plan to tell him that you had sold his property? Daniel had no answer. Andrew produced the purchase documents for the Ford F-150, dated 18 days after the property closed. He produced the closing documents for the Collingwood property, dated 26 days after. He produced records showing Daniel's declared income for the previous tax year was $43,000. Mr. Gauthier, how does a person with a declared income of $43,000 make a down payment of $110,000 on a recreational property? Hollis objected. The judge allowed the question. Daniel said it was from personal savings. Can you provide documentation of those savings? Statements? Prior year balances? We can provide them. Andrew looked at him. You've had 8 months of pre-trial discovery. We requested those documents in June. They haven't been provided. Why not? They're being compiled. They don't exist, do they, Mr. Gauthier? Justice Okafor delivered the ruling on a Thursday morning, 11 days after the trial concluded. I sat in the courtroom with Andrew on my left and Claire, who had flown back from Halifax for the ruling, on my right. The evidence is clear, Justice Okafor said. The defendant exercised a power of attorney granted under emergency conditions to benefit himself at the expense of the plaintiff. The sale of the plaintiff's property was not authorized under the scope of the instrument, was not conducted in the plaintiff's interest, and was concealed from the plaintiff for weeks afterward. The defendant's explanation that the funds were held in trust is not supported by any documentation whatsoever. Judgment for the plaintiff. $412,000 in damages. Prejudgment interest from the date of the unauthorized sale. Legal costs of the proceedings to be paid by the defendant. Total judgment. $468,000. Daniel sat at the defense table and stared at the surface in front of him. His lawyer put a hand briefly on his arm. I didn't look at either of them for long. Outside the courthouse, in the January cold, Claire put her arm through mine. We walked to the parking garage without speaking, our breath visible in the air. She had her mother's way of being present without filling the space with words. Andrew filed for enforcement immediately. The Collingwood property was the primary asset. Daniel's equity was approximately $140,000 after the mortgage balance and associated costs. His F-150, seized for auction, brought $24,000 net after the loan was discharged. Other identified accounts contained $71,000 that were frozen pursuant to the judgment. The CRA assessment arrived in February. It was comprehensive. Unreported proceeds of disposition from the baseline road property, calculated at the full $412,000. Adjusted cost base set at the original 2003 purchase price Patricia and I had paid, which was $218,000. Taxable capital gain, $194,000, half of which was included in income. Tax owing, $62,000. Gross negligence penalty, $15,500. Interest from the date the original return was filed. Total CRA assessment, $81,000. Due within 90 days. Daniel had no liquid assets. His accounts were frozen. His truck was gone. The chalet was restrained from sale by our injunction pending enforcement of the civil judgment. The CRA does not wait. They don't care about civil proceedings or family disputes, or whether a man feels his situation is unfair. They care about what is owed. I had spent 37 years watching the agency work. I knew what happened next. He called from his daughter Isabel's phone in late February. I'd kept Isabel's number unblocked. I heard the difference in his voice before he said a word. The anger of October was gone. What was left was something smaller and more honest. Robert, he said my name like it cost him something. I didn't speak. I don't have anything left. The CRA froze what was in my accounts. I can't sell the chalet. My lawyer stopped returning calls when the last retainer ran out. He stopped. I was wrong. I was wrong about all of it. I told myself it was temporary, that I'd figure out a way to make it right before you found out. But I knew. I knew when I signed those papers what I was doing. I sat in the kitchen where Patricia's plants were still growing in the window, the ones I'd learned to keep alive for her. You knew, I said. Yes. Patricia loved you. He made a sound I hadn't heard from him before. I know, he said. I know she did, I said. That's the part I won't forgive you for. I ended the call. The Collingwood property went to a court-ordered auction in March. Andrew and I drove up on a Saturday morning, 2.5 hours from Ottawa on the 417 and the 115. The escarpment coming into view on the horizon the way it does in late winter, gray and patient above the snow-covered fields. I'd been here once before, with Patricia, in another life. I registered as a bidder. Andrew had advised me on the mechanics. The property had an appraised value of $460,000. Court-ordered sales typically draw lower bids. Buyers understand there's urgency on the seller's side. The bidding opened at $280. It moved in increments, $300, $320, $345. At $360,000, I raised my paddle. There were 2 other bidders in the room. One dropped out. The other, a developer from Barrie, stayed in for another round. $370, $380. At $385,000, I raised my paddle again. The auctioneer scanned the room. The developer's agent made a call on his phone, listened, and shook his head. Sold to bidder 41 at $385,000. I drove home that evening through the tail end of a February snowstorm, the highway clear but the fields on either side white and still. The escarpment receded in my mirror. Andrew called while I was somewhere past Bancroft to confirm the paperwork. The net proceeds applied against the judgment. The remaining balance Daniel would carry as an active judgment against him for the rest of his earning life. My sister called me in April. She lives in Gatineau, across the river, and she and Daniel have always been close in the way that some siblings are close. Not because they're alike, but because neither of them ever quite fit anywhere else. She told me I'd been cruel, that Daniel had problems, had always had problems, and that family was supposed to account for that. That Patricia would be ashamed of me. I don't believe Patricia would be ashamed of me. I said, you destroyed his life. He made the choices that destroyed his life. I followed the law. She hung up. I haven't heard from her since. Claire came back in May with the children for a long weekend. We opened the cottage, which is what we were already calling the Collingwood property. In the first warm weekend of the year, the snow off the escarpment and the trails beginning to green. Liam wanted to know if there was a ski hill nearby. Sophie found a bird's nest in the eaves above the front door and made me promise we wouldn't disturb it. I stood on the back deck in the evening light and thought about Patricia, the way I do in places that are new and that I wish she could see. We'd stood near here once, 20 years ago, and looked at the same escarpment, and she'd said, "Maybe someday." I'd said, "Someday." Yes. I'd meant it as a promise I didn't know how to keep yet. "We got here, Patricia," I said quietly. Not the way we thought. The birds were loud in the trees around the property. The light on the escarpment was the color of old honey. Liam was inside somewhere, making noise, being 8 years old in the uncomplicated way of children who haven't yet learned to second-guess their own happiness. I went inside and made dinner. The wage garnishment order came through in the summer. Daniel had found work, production line at a distribution facility in Gloucester, East Ottawa, $22 an hour, 40 hours a week. The kind of job that pays the rent and not much else. Under the judgment enforcement, 25% of his net wages flow to me automatically. It isn't much. It isn't meant to be much. It's meant to be permanent. Every job he holds, every paycheck he receives, carries the weight of what he did and didn't do in a window of weeks when he thought no one was watching. I received a letter from Isabel in August, my niece. A handwritten letter, which I appreciated, on plain stationery. She said she loved her father and would always love him, but that she understood what he had done and she wanted me to know she didn't blame me for any of it. She said her mother, Daniel's second ex-wife, had told her years ago that her father struggled with the difference between what was his and what he wanted to be his. She said she hoped I was well. I wrote back. I told her she was exactly the kind of person her grandmother Patricia would have been proud to know. I told her the cottage was open in the summer if she ever wanted to come. I'm writing this in October. A year and a half since I came home from the hospital, and a year since the trial. Sitting in the chair by the window at Glebe Avenue with the maple out front gone fully red. I'll close the cottage for the winter next week, drive up on a Saturday, put the deck furniture in storage, drain the pipes, lock the front door. I'll come back in April when the snow is off the escarpment. My brother owes me a judgment he'll spend years paying down in small increments. The CRA will take what the CRA takes. His credit is closed to him for the foreseeable future. He's living, as far as I know, in a bachelor apartment in Orleans, east end of the city, working his production job, making his way through the consequences of a decision he made in a window of weeks, when he convinced himself there would be no consequences at all. He hasn't reached out again. I don't expect him to. People ask me sometimes, the way people do, whether I think what I did was too much, whether it was worth it, whether justice and family can coexist, or whether choosing one means giving up the other. I spent 37 years at the CRA watching people do the math on whether they'd get caught, whether the benefit was worth the risk, whether the rules that applied to everyone else applied to them. Most of them, when it fell apart, couldn't understand why consequences had followed from choices. They had decided they were a special case. They had decided the love or the trust or the access they'd been given was a license, when it was a responsibility. My brother had access to everything because I was in a hospital bed, and he was the closest person I trusted. He looked at that and saw an opening. He made his choice. I made mine. That's all it was in the end. Two people making choices, and then living in what those choices built. He built a prison he'll carry forward from job to job and year to year. I built a place on the escarpment where the light comes down through the trees in the evening, and my grandchildren sleep with their windows open, and the birds are loud in the morning. Patricia would have liked it there. She would have been up early, in the garden before anyone else, planning what she'd plant in the spring. She would have had opinions about the kitchen, which needs updating, and she would have been right. I'm getting to it. Please subscribe to Father's Reserved Revenge and share your thoughts in the comments below. If this story stayed with you, click on the next video to hear what happens when trust becomes the most expensive thing a person can offer. Thank you for watching.